Good afternoon, everybody. I'm Steve Allegrezza, Director of Digital Strategies and Marketing at IHFRA. I want to thank each of you for signing up for today's webinar. This is the second and final part of our webinar series featuring Adam Glazer and members of his team at Schoenberg, Finkel, Beederman, Bell, and Glazer, IHFRA's legal counsel. Our goal for this series is to ensure that our members are successful as possible through the pandemic and the disruptions it's had on our industry. If you've missed part one, where we discussed tax laws, traveling during the pandemic, and PPP loan forgiveness, please make sure you head over to our website and check it out. Before we start, I wanted to mention that we actually had well over 100 of our members sign up for this, which I think is a testament to the credibility and expertise of Adam, the relevance of the topics that we plan to discuss today, as well as your willingness to invest in yourselves. So without any further delay, it's my honor to introduce our presenter today, Adam Glazer, who is not only a partner at his firm, but he also maintains a specialized practice representing independent sales representatives nationwide. Today's topics will include recovering commissions under contracts, written and oral, state sales rep protection statutes, other extra-contractual recovery methods, and post-termination commission recovery, as well as more. I know Adam has a lot of useful information that he's ready to share. So with that, let me turn it over to Adam.
Okay, thanks very much, Steve. It's very good to be back with IHFRA. I very much value my relationship with the association, and thank you all for tuning in today. I hope it proves worthwhile, or at least as worthwhile as my colleagues set the bar last month for a very thorough presentation. What we're going to talk about today, of course, is the recovery of commissions when they're unpaid or underpaid. And I expect we're going to get a number of questions, at least I'm hoping for a number of questions, but fortunately, a number of you already submitted questions. So we have a number of areas to cover, a number of different places to go. I have arranged the presentation so that I'm going to discuss some general commission recovery propositions and some different bases where we might be able to obtain commissions. And at the end, I will incorporate the questions that I have received to date, and certainly any additional questions that you have or that pop up during the presentation. You can use the chat function in Zoom. Steve will monitor those, and we will come back to those at the end. And I hope it'll all prove to be worthwhile. Steve, I noticed that we do have somebody in the waiting room. I know you're on top of that. But if you have, it probably shows up on my screen because you have made me a co-host. So
correct.
I am going to begin a PowerPoint presentation that I have put together covering a few different areas. I'm not a big fan of PowerPoints, so I will try to keep this reasonably short. I think it does help to get some of the ideas in front of you in written form. Hopefully it'll make more sense than if I just tell you about them when you can actually see some of this illustrated. And we'll walk through this together. Let me see if I can share my screen with you now. Let's see if I can make this work here. Okay. All right, so this is me. Of course, Steve already told you that. What we're going to do is we're also going to cover some other important areas beyond just who I am. The beginning that we're going to get to is going to be, here's an overview of what we're going to cover. We're going to discuss contracts, since most of the recovery for a sales rep is based on a contract, whether it's written or oral. Alternative to the contract are legal theories, the most prominent of which is the procuring cause theory, which I will explain. There are many statutes that also protect reps in many different states. We're going to cover those, and then we'll briefly touch on some other potential means to recover commissions. There are a number of different tools that we use, and sometimes we use all of them. Sometimes we only are eligible to use one or two. but we will have all of these available to discuss anyhow whenever there is a commission recovery. recovery issue. Now, you already know I'm confident that when a commission goes unpaid and you call me up and you say, Adam, what do I do here? My answer is never going to be, let's immediately charge into court and file a lawsuit. That's usually the last resort. We will instead try and approach these from a different manner. We will find out about what efforts have been made to date. You'll explain to me what's been done. And usually we begin with a easier, softer approach in the form of a demand letter or an email or some attempt to open up a dialogue with the factory or its attorneys and try and figure out if there's a way to do this informally and work towards some sort of amicable resolution. But if there isn't, that's when all of these theories come in. That's when we try and apply these as best we can to recover what is rightfully yours. So we always begin by taking a look at the contract, if there's a written contract. You always begin looking at your rights under the contract. What obligations are imposed on the factory under the contract? Usually there are going to be commission obligations that will be set forth in an exhibit to the contract, and we'll look to see exactly what your rights are under the contract. Assuming there was a breach of the contract, it has to be a material breach. No one's going to take action. No judge is going to receive an action for a immaterial breach. It has to be something substantive in order to take this seriously. And then, of course, the other element of a contract is that there have to have been damages suffered from the breach. I'm not going to take you all through law school, but the basic elements of a contract action are the existence of a contract, a material breach of the contract, and damages resulting from the breach. If we have all of this, we can go forward with a contract-based claim. One other consideration, of course, and I always tell reps this up front, is whether there is any potential for a counterclaim, because most lawyers understand that the best defense is a good offense. So if there is a claim to be brought against a factory, they are going to consider, or their attorney is going to consider, whether the factory can file any kind of counterclaim. That usually is not taken seriously. When they do that, it's usually nonsense like failed to use best efforts or some other amorphous claim like that. But we always want to talk about this up front just to make sure there isn't something more important lurking out there, like any possible breach of a non-compete agreement. So,
hey, Adam.
Yes.
Sorry, I'm so sorry let me quickly interrupt. I'm going to steal the host back from you real fast. If everyone can make sure, if you called in, can you please make sure you mute your phone? We're getting a lot of background noise and we don't want to interrupt this presentation. And let me see if I can hand this back over to you, Adam. Sorry about that.
Sure.
Actually, can you still, I think your screen is still showing up. I think you're
okay,
good.
All right, we'll just keep going then.
Okay.
So in terms of a contract, we're going to review the commission and the termination rights under a contract. Some of those important obligations include looking at when payment is due. It varies with the contract. Sometimes when the order is received, sometimes on shipment, sometimes when the factory gets paid. We look at when the commission obligations are due to determine just what you're eligible for. We also look at things like the discretion the factory enjoys. Come to me with a commission claim, I'm going to look to see, well, is there language in the agreement? Again, assuming for purposes of this slide that it's a written agreement, we'll look to see whether the factory has reserved the discretion to change the commission rate unilaterally. Is that within their discretion? Can they change your territory? Can they add house accounts? Do they control the method by which splits are taken? These are all provisions that vary contract to contract, but they're always important. And if there was going to be a part 3 of this this webinar series, it might be on contract provisions, on drafting contracts. Perhaps, Steve, that'll be for a future webinar. But we would always encourage that when contracts are prepared, to resist the factory's temptation to bestow it with tremendous discretion to change things like commission rates and territories, because all of the work that you do up front to try to negotiate a fair contract is often taken away if they have the discretion to change it after the fact. So you look at things like that. Does the contract provide for an automatic renewal? In other words, is there an evergreen provision that says the contract will continue unless it is canceled within 60 days of the renewal date? Not always does the factory enjoy the right to terminate it at its discretion. It has to be language in there. it does have a right to terminate rather than just a failure to automatically renew a contract, what does it say about their termination rights? Can they do it with cause? Can they do it without cause? Can they do it for any reason or no reason? Most rep contracts, of course, say that. Most contracts say you can terminate, either party can terminate for any reason or no reason on 30 days written notice. It's not uncommon, but what it of course means is that even though it's a contract with a 3-year term, it's really a 30-day contract. Most of you already know that, but we'll look to see exactly what it says. Bear in mind that even if the contract says that it can be terminated without cause, even if it can be terminated for no reason, that does not mean it can be terminated in bad faith. A rep cannot be terminated simply to avoid the payment of a commission that's due or that will become due. That is a bad faith termination. I'm not saying it doesn't happen, but courts recognize that a bad faith termination is a termination that we can show, never mind what the truth is. It has to involve what we can prove. If we can prove that the termination was solely to avoid a commission obligation, that is generally speaking considered to be a bad faith termination. And then many contracts provide for payments post-termination. Some provide 30 days, 90 days. Some tie it into the number of years that the rep has served the principal. So there are all kinds of different methods, and we'll look at that as well. Let's see what the contract says about post-termination rights. I'll get into post-termination in some depth in a little bit under this procuring cause doctrine theory I mentioned, but we start with the language in the agreement. What does it say about post-termination rights? Finally, we'll look to see, at least it's not finally because we'll look at everything, but among the things we will look at are whether a agreement states any kind of non-compete or non-solicitation obligations on the rep. Obviously, these are in here in many of these contracts. Some of the questions we got to deal with this, so we'll come back to it. But a non-solicitation provision, hope everybody knows what that means. It means after termination of an agreement or during the contract term, it'll say the rep can't solicit away either employees of the factory or customers of the factory for a certain period of time. We always encourage that any such provisions, if they have to be in here, should be mutual. If you can't pirate away their employees, they shouldn't be able to pirate away your key employees upon termination. Non-competition is a different story. We will, generally speaking, never advise reps to agree to any post-termination non-compete unless the factory is prepared to pay you for the time that you have to sit on your hands and not do business. But it doesn't mean that many contracts don't contain these provisions. Let's talk about oral contracts because I know they're very heavy in your industry. I know IHFRA members oftentimes have oral contracts, and there is nothing unenforceable about an oral contract. I get a lot of calls that say, Adam, I didn't have a contract, even though I've been repping this principal for 15 years. All we did was agree to certain terms before I started soliciting for them. Well, of course, that is a contract. That is an oral agreement, and every state will enforce an oral agreement. The rules are a little different sometimes with oral contracts, as I state here, but generally speaking, it's the same elements of proof that have to be provided. And as we often say, an oral agreement is sometimes better than a bad written agreement. You give me a provision like this, take Arizona for 4%. Okay, that's a statement made to you in the old days when we had personal meetings. Perhaps now it's stated in a phone call. I'll take that. I can deal with that kind of oral agreement. It's not as easy as a 12-page single-spaced agreement, but I can work with this. It's much better than a written agreement that comes out of the factory lawyer's shop that has all kinds of terrible language in it from the rep's perspective. But you have to know that oral agreements are enforceable. All right, now here's what I mentioned before, and I have this in here, and it's somewhat prominent because procuring cause doctrine applies to oral contracts. Sometimes it's the best situation to invoke the procuring cause doctrine. It's not very well known. Most of you don't know about it. More importantly, most of your factories don't know about it. The procuring cause doctrine provides or I should say it enables reps to get paid commissions on sales made after the effective date of termination if those sales were procured by the rep during the contract term. If you worked on a case and your hard work, your efforts brought in sales that continue after termination, then that creates a windfall for the principal. If he gets that business only because of your efforts, only now he doesn't have to pay the commission, and he keeps that last little sliver of the pie for himself, that's a windfall to which we argue he's not entitled to. And unless the contract specifies otherwise, those commissions should remain due to the rep. This doctrine is a common law doctrine, meaning it's not in a statute anywhere. It's developed from the case law, that it says that unless the contract specifically limits your post-termination rights, then those sales are commissionable to you. The application of this doctrine varies in the different states, but it generally applies to enable the rep to recover post-termination sales if you procured the sales pre-termination. The concept here is it's an equitable doctrine. It's not something, as I say, that comes out of the statutes that legislatures pass. We're going to come to statutes in a minute, but this is something that courts have recognized. It rose up out of the real estate context. Consider a real estate broker who shows you a house, and you like the house, but you and the seller of the house get to talking, and you learn that the real estate broker's contract is up in 2 weeks. So you agree you're going to wait for 3 weeks and then buy the house, and you save the real estate broker's commission and you split it among the two of you. Well, the real estate broker finds out about that, of course. He knows that you never would have found that house if he hadn't shown it to you. It's the perfect house for you. And the real estate broker sues and says, even though my contract is up, that deal took place because of the work I did during the contract term. I found a buyer ready, willing, and able to close on the house. That's all I can do as a real estate broker. And the courts have recognized that and protected him from getting deprived of his commission in that context. So I'm sure all of you can see the application as well to a sales rep. A sales rep does the work and then gets terminated. The sales rep should remain eligible for the commissions. And that's what this doctrine does. It's not accepted in every state. It's not accepted in every judge by the states that do accept it, but it's another tool in the arsenal. It applies by default unless the contract states otherwise. You're usually entitled, many states are usually entitled to the benefit of this rule, which is why oral contracts are so important, because if you have an oral agreement, it would be most unusual for the principal and the rep to have agreed to limit the post-termination commissions. That kind of language is generally only found in written agreements. So this is something that can be very beneficial to reps with oral agreements. I just want to share some language with you to show you how the courts have applied this. Here's a case out of California where a rep didn't even know about the business closing, of course, because he's been terminated. But nonetheless, the court recognized that the deal would not have taken place if it wasn't for the rep. And therefore, the fact that he wasn't involved in consummating the deal did not prevent him from recovering the commissions. As long as his pre-termination work led to those sales, and without an agreement to the contrary, courts find these sales to be commissionable. It's very simple. Here is a sample. Here's a sample provision. Here is a provision that you have perhaps seen in many of your own contracts. This is a termination clause. It's very common. Something that I venture to say you have all seen something like this, or very close to this. But what's important here is to look at the language that says, upon termination, commissions shall be paid on purchase orders placed and shipments made up to the effective date of termination. Okay, here you could say, okay, well, this contract specifically states that the rep will be paid on orders that are placed and shipped up to the effective date of termination. So since this contract states that, does this render the procuring cause doctrine inapplicable? And as they taught us in law school, the answer is it depends. This is not necessarily preclusive. Follow me on this, okay? This says what you will get paid on orders placed and shipments made up to the effective date of termination. So what happens to the orders that come in after the effective date of termination? The argument we make in many cases is that this language does not address that. It does not cover post-termination orders. It only talks about how you're going to get paid on orders pre-termination or up to termination. So the world of post-termination orders is not addressed, and therefore the default procuring cause rule should apply. It's an argument we've had mixed success with. I'm not telling you it's a magic bullet, but this is not kind of language that ends the consideration of trying to recover commissions. We say manufacturers have to be much more precise if the intention in their contracts is to limit or exclude post-termination commissions. What else do manufacturers say about this? These are their arguments most often. They point to the fact that the contract says nothing about paying post-termination commissions. How can we be responsible for paying post-termination commissions when we didn't agree to it in the contract? Well, that's the whole point. It is a default rule. It applies unless the contract says we will not pay you. If the contract does not expressly preclude these commissions, then they remain payable. That is what the case laws say. That's what judges have found on this doctrine. Other arguments they make. Well, we weren't even the ones who terminated. The rep terminated this deal. Really, termination doesn't matter. That's not the point. The point is, what does the contract language say? It doesn't relate to who terminated. Finally, they argue the rep isn't even the procuring cause. We did all the work. We called on these customers. We provided the services. Well, that is a good argument. If they can show that the rep did not procure the business, then the rep would not be eligible. The doctrine would still apply, but the rep would not be eligible to collect under the procuring cause doctrine if the rep was not, in fact, the procuring cause. But the argument here is we have to show that we did everything that we were required to do, and ultimately this is for the jury to determine. So if a manufacturer comes in response to our complaint and files a motion to dismiss or a motion for summary judgment because they think that they can show that they were the procuring cause, not us, that's usually a jury question. That usually gets decided at the end of the day, and that leaves the principals with every incentive to try to settle a case. All right, I think that's enough on procuring cause. Let's move on, but I'll answer questions later if you have them. Let's move on to the sales rep protection statutes. Feel free to use the chat function. Steve will keep track of all of those questions. In addition to the contract and in addition to the common law, most states have enacted specific statutes that protect sales reps. Not every state. It's about 36 states that have these on the books. So if you're from Delaware, you're not likely to take advantage of something like this. If you're from Florida, you're not likely to do this. Florida had a statute, but then it repealed it. But most states do have statutes that protect sales reps who don't get paid. Typically, you have to show that you're doing business in the state or you're from the state, that the principal uses sales reps to solicit orders, and that the sales rep gets paid in whole or in part by commission. Then you're eligible. All of these statutes cover reps who are due payments of commissions upon termination. Most of these also cover post-termination payments, payments that become due after the termination. And what's the beauty of these statutes? Why would we invoke these? Because most of them impose what is a punitive case against the principal who pays late. Reps can be eligible, in addition to the unpaid commissions, for 2 or 3 times the unpaid commissions, plus attorney's fees. Very important. The idea here is that most legislatures who have enacted these statutes, they recognize that reps and principals are not playing on a level playing field, that the principal has all the advantage, that the principal is the one who can squeeze, and reps are unfortunately very vulnerable. So what these statutes do in most of these states is enable the rep to try to level the playing field and say, if you don't pay me on a timely basis, you can be liable for 2 or 3 times the amount of unpaid commissions. A rep may not feel that a claim by itself is worth pursuing, but when you have the potential to recover 2 or 3 times the unpaid commissions, plus recover back your fees, then all of a sudden it could be a different analysis. The equation could look much differently. And believe me, this has considerable leverage when trying to settle a matter, when trying to get paid, with the idea that a principal learns for the first time that there is a sales rep protection statute that covers the rep and potentially faces liability of 2 or 3 times. The accountants at the company start looking at it very differently, and oftentimes a settlement can result, even though they won't acknowledge this, but rather than face the potential for these kind of damages, things can happen that make the rep's position a whole lot stronger. Here are some other theories that we sometimes use: unjust enrichment or quantum Meruit. These presume that there is no contract, that there's no binding written contract, there's no binding oral contract. Then you have another basis to say that you can still go after a principal who does not pay on the general concept of fairness, and unjust enrichment suggests that the principal is unjustly enriched, as the name of the theory, by your efforts, and that it would be unconscionable to allow him to continue that position and the rep receives no funding. How does this work? Well, sometimes if you have a written contract or even an oral contract and it expires, everybody agrees that the contract expired, but both parties continue working. The rep continues after the contract's expiration, generating sales, and for a period, the factory continues paying the rep as it had before. Now's when you fall into some period where you don't have the existence of a formal contract, but there is essentially an informal or an implied contract that continues to exist. And there are certain legal rights here that protect the sales rep in those circumstances. That's what the concept of quantum Meruit, as much as he deserves, that's the idea that the rep has provided a service, the service has value, and the rep deserves to be compensated for that in the absence of a formal agreement. So those are some ideas about the commission recovery theories. Now, ordinarily, here's where I would open it up to questions. However, due to Steve's anticipatory actions, we already have many of the questions. They've already been submitted. So let me try and plunge into some of those questions with the slides I've already shown you as the background. So some of the questions that we've already submitted, I've tried to organize these in what I think is a logical fashion. The question was asked, do signed independent rep agreements hold up when voluntarily entered into between independent sales rep and independent factory? Well, of course, that's the whole premise of the idea of the contract-based theory. Parties can freely contract. It's in the Constitution. So contracting parties have great discretion to agree to any business terms that they choose. They don't have to be fair. They don't have to be equitable. If the parties in an arm's length transaction decided to enter into an agreement, the presumption will be that the agreement is enforceable. Very tough to get a written contract between two business entities thrown out on the idea that it's unfair. It really has to, what they say, the expression they use is shock the judicial conscience for a contract to be so one-sided, so unfair that a court won't enforce it. So generally, they're going to hold up. Question is asked, a line promised me monthly payments. We made the deal on a handshake and my foolish honesty and good faith. As I was dropping the line, I learned 9 whole payments missed. The sales manager claimed correctly, I'm afraid, that we never made out a written contract. Well, so if you've been following me as I've been droning on in this presentation, you know that it doesn't matter that you never made a written contract. That may be true. But if both sides have been performing and you had a handshake deal, that is an oral contract. And that oral contract is enforceable in all 50 states. So performance is an indication that a contract exists. And if they haven't paid you for 9 months or 9 payments when you were dropping the line, those payments should be recoverable. There may be other considerations, but it will not be, they will not fail to be recoverable simply because you do not have a written contract. All right, here are some more questions that I received. They're all based on, these questions are organized based on the contract. You'll see a factory is refusing to commission me on one sale until I collect on another for them. How do I obtain the payment I am due? Next question, I was moved from a salary to a guaranteed commission in May. By July, the factory stopped shipping into my territory because they took care of bigger dealers under owner and sales manager accounts. Any recourse? Can a factory withhold commissions due if you get a PPP loan? And there was one more here. Bear with me. There we go. Are commission reps paid severance? I have all of these organized like this because the answers to all of these are essentially the same. What does the contract say? If there's an oral contract, what did you agree to orally? Because the answers to all of these should be found in the contract. A factory is refusing to commission me until I collect on another for them. How do I obtain the payment I am due? Well, the answer to that, maybe you have to sue them under the contract. If the contract does not enable the factory to prioritize payment in that manner, then they are in breach. The second question, the factory stopped shipping into my territory because they took care of bigger dealers? Does the contract say anything about that? Do they have that discretion? Are they permitted under the circumstances? Did you sign off and agree to that? Did you shake hands and agree to that kind of arrangement to enable them to do that? Can a factory withhold commissions if you get a PPP loan? Well, the answer to that's almost certainly no. I mean, that's ridiculous. But if there's anything in the contract that says that they're entitled to do something like that, then they could do it. If you've agreed to that, and if you get some sort of major loan, it reduces or delays or eliminates the factory's obligation to commission you, then maybe they can point to something. And are commission reps paid severance? Well, of course, independent reps are not employees, so you would not ordinarily expect to receive any kind of severance benefits. But look at what the contract says. If it's in there, if you are shrewd enough to negotiate a severance as an independent rep, then they may have to pay you a severance benefit. But all of these depend on what the contract says. So if it's not in the contract, if any of these propositions are not covered, if the principal doesn't have a contractual basis for taking this action, then the answer is they do not have a legal justification for doing this. Doesn't mean they can't exploit the situation and try to get away with it, but you would, as the sales rep, as the contracting party, oral or written, you would have the ability to push back and to demand they comply with the contract. Here, the next group of questions I frame as legal questions. Here's something that I know a number of folks were asking about. What is the statute of limitations when attempting to recover unpaid commissions? The statute of limitations differs state to state. There's no federal statute of limitations for contract cases or for sales rep matters. Sometimes statutes of limitations differ within a state based on whether it's an oral or a written contract. Here in Illinois, where I'm based, even though I practice for sales reps all over the country, the statute of limitations for an oral contract is 5 years, but for written contracts, it's 10 years. So usually a sales rep has plenty of time to bring a claim. Other states, the statutes of limitations are the same for oral or written contracts. Other states, they can be shorter, they can be longer. Some states, the statute of limitations is only 2 years. Some states, I believe it's only 1 year. So it varies. But you generally have a reasonable opportunity to bring a claim. Now, mind you, many rep contracts, written contracts, will contain attempts to shorten the statute. We'll have language in there that say any claims for any discrepancies in commission payments have to be brought within 30 days or 60 days after the commission check is tendered or after a commission report is tendered. Oh, that language isn't always enforceable, but it is something that we have to deal with. So keep in mind that your concern is not just what the statute of limitations is, but you also want to pay attention to what your contractual limitations period is. The question is asked, is my signed non-compete agreement enforceable? My contract says I cannot sell a particular category for 6 months after termination or quitting. Isn't this restricting me from making a living? A restraint of trade? Well, the answer to those last two questions is a big yes. It is a restriction and it is a restraint. That doesn't necessarily make it unlawful. Again, it depends where you are. Florida is very fond of restrictive covenants. California is just the opposite. California is very reluctant to enforce restrictive covenants. The trend in the law, I believe, is away from these kind of restrictive covenants. Most actions today in states are in favor of allowing reps and other workers to ply their trade, not to be held back by a non-compete agreement. But many states will still enforce a reasonable non-compete agreement. Remember, this isn't something that the factory is imposing unilaterally on the sales rep. This is something that you agreed to up front. You knew about it when you signed the contract, and you agreed to it by signing that you would not engage in competitive activity within 6 months, in this case, after the contract is terminated. Now, that's not the end of the inquiry. You still have to look to make sure it's a reasonable restriction. Is it reasonable as to the time period? Is it reasonable as to the geographic area that's imposed? Is it reasonable as to the accounts on which you are restricted from calling upon? All of this will come into the court's analysis. There are all kinds of factors that are used. So just because the contract has a clause doesn't mean it will be enforceable. But I can't tell you that all of these agreements are unenforceable. It depends on how it's worded, depends on where you're located, what state, and it depends, of course, on just what kind of restrictions are sought to be imposed. If they are reasonable restrictions, if it's for a reasonable time period, if you've agreed to it in writing, and if you're in a state that authorizes restrictive covenants, these may be enforceable. But there's a lot of different qualifiers there, and they all have to be met before they could be brought up by a factory. This is why I said at the beginning, we generally will never advise a sales rep to sign any kind of post-termination restrictive covenant, because it doesn't serve anybody's purpose. Really, it doesn't even serve the manufacturer's purpose, and it's very expensive when you get involved in litigating these, and they are, generally speaking, hard to enforce. The third bucket here, a lot of questions about what recourse do I have? Do you have any recourse when you're terminated after increasing the company's sales 400%? Is there any recourse when a company lets you go without giving you a reason? A Florida factory went direct to retailers and trade customers, cutting out the reps. They never terminated us, they just stopped paying us. I tried to contact them and even engaged a collection agency. Nothing worked. What is my recourse? These are all very good questions. Let's start at the beginning here. Do you have any recourse when terminated after increasing a company's sales 400%? I'm afraid factories are entitled to make bad decisions. It's not unlawful to make a dumb business decision. And certainly if you drove their sales 400%, they must have a pretty compelling reason to terminate you. Hopefully it's something other than their brother-in-law has moved into the territory and he's a sales rep. But do you have any recourse? It all depends on how your contract is worded. Assuming your agreement enables a factory to terminate for any reason or for no reason, then they can terminate you. As I said before, they can't terminate just to avoid a commission obligation, but your successful track record is no obstacle to getting terminated. You know, they say there's two times when a sales rep gets terminated, right? When you don't make any sales, and when you make too many sales. And if you're too successful and you're getting paid more than the company president based on your commission deal, you got to look over your shoulder. You got to be nervous about that. And unfortunately, if that's the situation here, as long as there's no bad faith conduct, they can terminate you, depending how the contract's worded. And by the way, that's only true in most of the states. Earlier, we talked about the sales rep statutes. I told you that those sales rep protection statutes vary state to state. Just in case you happen to be in Minnesota, if you're a Minnesota rep or your territory includes Minnesota, that sales rep statute is unique, and it does not enable a factory to terminate without cause. There you have to have good cause to terminate, and good cause is defined in the statute, and it does not include being successful. And even then, when they have good cause to terminate, they have to give you notice and an opportunity to cure the reasons for termination. So in case you're in Minnesota, you may be in a better situation here in response to this first question. Next question, is there any recourse when a company lets you go without giving you a reason? Well, unless the contract states that they're required to give you a reason, there's no recourse simply because they failed to give you a reason. You don't always get that reason. You may feel you're entitled to it, you may deserve it, but it's not always the case. It doesn't always work that way. Okay, I just lost my question here. See if I can go back. Here we go. Yeah. Again, it'd be a bad business decision not to give you a reason. But when I was younger, I got broken up with by girls who never gave me a reason, and what was I going to do about it? I couldn't really push too hard. Obviously, the idea here is that you want to make sure that they do not have a reason to let you go, but if they do, you want to make sure you get paid what you're owed. You want to make sure that you recover everything they owe you, including on a post-termination basis, which, depending on the contract, takes us back perhaps to the procuring cause doctrine. And as to the factory in Florida, they just stopped paying you. So if the contract wasn't terminated, then you are still the sales rep. You tried to contact them. You even sent a collection agency after them. You didn't get paid. What is my recourse? I'm afraid the recourse is to sue them. I'm afraid you have to invoke the legal process here. You've tried everything. The idea here is that they're not taking you seriously. They think you're going to go away. Maybe they have hotter fires that are burning right now than you. Maybe the amount is not sufficient to get their attention. I don't know. But if they owe you commissions, and if you haven't been terminated, those commission obligations are continuing, you may need to get a lawyer involved to collect that. That seems to be the logical next step. All right, and then one last question that I was asked that I'm putting up here now. Will I do better using an attorney or a small claims court just as viable an option? Okay, so if the amount is small enough that you are eligible for a small claims court, chances are you don't want to use an attorney. We're talking about a few $1,000s. It would cost you that much money or more to recover the money. And certainly you don't want to spend $5,000 to recover $5,000. So you either forget about it, or in fact, small claims may be a very good option for you. Head over to the small claims court. The clerk will be very helpful, should be very helpful, and you can file something yourself down there. Ordinarily, companies have to have attorneys, unlike you as a sales rep, unless you're incorporated. If you're incorporated, you have to have an attorney, and small claims may not be an option. At least that's the rule here in Illinois. But in general, will I do better using an attorney? Of course, that's up to you to decide. Sometimes when you have a aneurysm, you think maybe you can treat it yourself. You don't need to go see a doctor for that. Good luck to you. Situations like this, I just want to tell you that, if you're involved in a heavy contract action, if there's enough money at stake that makes it worthwhile and perhaps even enable you to recover attorney's fees at the end of the day, either because your contract has an attorney's fees provision or because the statute enables you to recover attorney's fees, it may be a very easy decision for you to make. So what I think we're going to do is we're going to take any other questions that you have. They'll come in the chat room, and I can hear about them from Steve, and we can try to cover them. And then maybe if we want, we can even have a discussion about this if others want to weigh in on some of these points. So Steve, I think we're co-hosting this conference now, so you should be able to step in and help me out with any questions that I haven't addressed so far.
Sure. And we've received several in the chat. So I'm going to just try to go in the order in that they were received. First one that came in was, how long can a procuring cause doctrine remain in place after the contract has been terminated?
Right. It's a great question. It really is. I hear that question asked a lot. I hear it asked by defense attorneys. I hear it asked by judges. Even if you're entitled to recover under the procuring cause doctrine, Adam, for how long? Is it, do you get commissions in perpetuity? Do you get them in perpetuity and beyond? Does not only your client get those commissions, but his grandchildren get those commissions as well? The answer to that is that there is no firmly determined answer to that, and that shouldn't frustrate you, because that's the case in many situations. If I am a personal injury lawyer and I'm trying a case in front of a jury for my client who has lost an arm through a defective product, there's no rule that says what a severed arm is worth. I don't take out a book and say a severed arm is worth X number of dollars and that's what you should award. I have to make a case to the jury about why that severed arm is worth the amount that I am seeking. If I ask for too much money for a severed arm, the jury is not going to give it to me. It's not going to take me seriously. If I ask for a reasonable amount of compensation for that lost arm, I would hope the jury would give it to me if I've proven my case. And it is the same with post-termination commissions. If I were to ask the jury to award commissions for 75 years after the relationship terminates, perhaps they won't take me seriously. If I come in and I act reasonably and I suggest to the jury and I back it up with evidence at trial that it's industry standard or it's appropriate or it's customary to award commissions for 2 years or 3 years or 5 years, or depending on the industry, 10 years. Or perhaps if I'm in the automotive industry or other industries where life of the part and life of the program is the standard commission payment, I may ask for that. So it all depends, as I mentioned to you earlier, a lawyer's standard answer for any question. It is a reasonable period of time that you seek to invoke the procuring cause doctrine for. You ask the judge or the jury to award commissions on a time period that is reasonable under the circumstances, but there's no blanket answer to that. There's nothing that covers every situation.
Okay. One question that came in that's sort of related, now I'm skipping around a little bit, is, how can you force a company to share with you the orders that are in the system? Like if you've written orders, but you're terminated, how can you make sure that you get paid on all those open orders?
Contractually. You can make sure about it contractually. When you negotiate the contract, you should put in there that the factory is obliged to provide commission reports, not only during the contract term, but for X number of months after the contract expires. It should correspond to any post-termination rights you have in the contract. But it's a good question, because certainly no factory is going to provide any kind of post-termination data that they don't have to provide. So what we typically will do, assuming the contract doesn't require the production of those kinds of reports, is when we get involved and we are interacting with the company's attorney, either by email or by letters, we will demand production of those reports, and they will tell us, why should we give them to you? And the answer is, because if we have to file a lawsuit, we will get them in the discovery process, and we will. So oftentimes we get those reports. And after all, the sales records shouldn't be disputed in these cases. I'm not saying they're not, though oftentimes they are, but receiving the sales records should be fairly easy, because they are what they are. There's nothing about them that will change based on the nature of the litigation. So if we don't get them in the pre-filing, we absolutely will get them in court, because we're entitled to them. We will serve a discovery request, and the factory will perhaps fight it, but ultimately we will get those sales records. Why? Because they're relevant to our claim. So most smart lawyers defending the company will know that we will get them, and they will make them available in some form or another. Oftentimes they take the form of a spreadsheet that somebody prepares. I don't usually settle for a spreadsheet. I want the underlying data that the spreadsheet is based on. But for settlement purposes, sometimes the spreadsheet will suffice. and we will see what the factory is representing those orders were. And I share that information with my client, the rep, and we decide whether that's reasonable, whether that's consistent with the history from the territory, and whether the factory is playing fairly or not. If not, we'll get the information in discovery.
Okay, and kind of piggybacking off that the last portion of your response there about, sometimes they'll want to supply a spreadsheet, or sometimes you want the actual data. How do you avoid a he said she said situation? Someone asked, how can you prove an oral contract if they denied that you had an oral contract? Isn't the fact that you've been paid in the past for that service proof?
Right. Sure. Right. And that's not limited to the sales rep context, of course. That's in any business context where one party will say, the agreement was this, and the other party will say, no, the agreement was something else. And you look at a number of things. You look, first of all, were there any other witnesses? Were there any records? Were any notes kept? Was anybody else in the room when the deal was made, or when any subsequent conversations were held? Were there subsequent emails that were exchanged after the oral agreement was reached that are reflective of what the terms may have been? Were there any discussions with other people that will illuminate what the terms were? All things you find out during the discovery process. But just as significantly, yes, you do look at how has the relationship been governed up till now? Well, ever since the alleged oral contract was reached, we covered these 3 states, we sold these 12 products, and we received this percentage in commission dollars. That sounds a lot like it's an oral contract. So sometimes you prove an oral contract by performance, by what both sides had done since the time of the agreement, and whether one side compensated the other in exchange. So you have performance by both sides. That's usually highly illustrative of the terms of an oral agreement.
Okay. Let's see. We've got another question here. It's a little different. If you contract with the rep group and the rep group is contracted with the manufacturer, do you have any rights if commissions aren't paid by the manufacturer?
Well, okay. I understand the question. Does everybody else understand? It sounds like you're talking about a sub-rep who contracts with the rep who has the contract with the factory. So typically the sub-rep would not be able to go after the factory because there's no contract between the sub-rep and the factory. It would be the rep's job, who has the contract with the factory, to lay claim to those unpaid commissions. And then of course the sub-rep would be a beneficiary of that arrangement. Sometimes you could also, somehow piggyback along in the case, but it would be harder for the sub-rep to go after the rep than go after the factory directly, because the factory could credibly claim in defense, you have no contractual right with me. There's no privity of contract, to use a legal term. So I don't owe any duty to the sub-rep. So it involves getting the direct rep involved, the one who does have the contractual relationship. And then if for any reason the contracting sales rep doesn't pay the sub-rep, then the sub-rep can come after the direct rep, the rep who he has a contract with.
Okay. Let's see. We've got a few more questions, and then I've actually got one of my own here. What are the options for a manufacturer to kind of to claw back overpayments or payments made to me in error?
Okay, so many of you know what my answer to that's going to be, right? It depends on what the contract says. Sometimes contracts say specifically that principals have the right to recover overpayments, or they can deduct that amount from future commission payments if there is some sort of mistake made, or just like if there are returns made by the customer and so forth. Oftentimes that's set out in the contract. Even when it's not set out, oftentimes factories will just do it anyhow. We'll just say, you were overpaid, we took this step, and we did it. Do they have a contractual right to do that? No. But is that the kind of situation where I would recommend taking legal action? Only if they did it improperly, only if we can show that they are trying to extract from the rep savings that the rep is not responsible for. If there was a mistake, but it didn't involve the rep, and they're trying to take it out of the rep's hide to make themselves look good, then yes, we take action. But if there's anything to that claim that the rep was overpaid, even though they don't have a contractual right to do it, it's not a good fight to get into to say you took that action without a contractual right. You may be right, but they may have other bases to get away with that. So it's the kind of situation that's usually covered by a contractual term. But if it's not, it really has to be looked at carefully to see A, if the dollar amount is worth pursuing, and B, whether the factor at the end of the day will have a leg to stand on for making those deductions.
Okay. And we've got two questions that are somewhat similar. So first one asked, does any of this apply to our friends up in the north in the Canadian market?
Yes, I saw we got a couple of those questions ahead of time. I'm afraid to say I am not a Canadian lawyer. I don't have any license to practice in Canada, and I don't have a good answer to that question. What I can tell you is that I have represented Canadian sales reps before, but in actions pending in the United States. A Canadian rep with a territory in Canada who contracts with a U.S. factory can usually bring the claim in the United States, and then they'll be protected under the U.S. laws the same way as the same way as the U.S. reps are. Not in every state, but in many states that's the case. So you can take advantage of U.S. laws. I don't know what the sales rep protection laws are in Canada. However, I do know lawyers in Canada, and I could perhaps refer you to a Canadian lawyer if you want to contact me after this webinar is over, and maybe they would be the ones to help answer your questions about the effect of these principles up north.
Okay. And another question that came in is it the law in which the state, is the law relevant to the state where the factory is located, or is it bound by the law in the state in which the rep resides?
Okay.
Hopefully I asked that correctly.
Right, now I understand the question. I'm guessing that a number of you know my answer already, right? What does the contract say? The contract will often provide for what state's law will apply. It will state in there, this contract will be construed and governed by the laws of the state of Indiana, which is not the end of the inquiry, by the way. There's a number of things to consider. I mean, does Indiana actually have a connection to the case? If neither the rep nor the principal are located in Indiana, it's just that the principal's lawyers thought the laws of Indiana were very good and they chose Indiana, then that probably is subject to challenge, because the law that's invoked in the contract has to have some logical connection to the parties and to the actions to be taken under the contract. It's also subject to, let's go back to the sales rep protection statutes that I mentioned. In fact, most of these sales rep protection statutes include non-waiver language. What do I mean by non-waiver language? If the legislature of any of these states, including, let's say, Minnesota, since I brought up their statute, then if the legislature in Minnesota is careful enough to provide these specific protections to Minnesota reps, they don't want to see that a factory can easily, comfortably do away with those protections by simply stating in their contract that if you're going to do business with us, your contract will be governed by the laws of New York. New York is far less favorable to a sales rep. So if they could do it that easily, just put in the contract that New York law applies, then the Minnesota's legislature's careful actions are defeated. So they have language in there that says the protections afforded under this statute, the sales rep protection statute, cannot be displaced by making the contract subject to the laws of another state. Any attempt to make the contract subject to the laws of another state are null and void. So a Minnesota sales rep can still invoke the Minnesota sales rep statute, even if the contract says New York law applies. But generally speaking, the answer to the question that was asked about whose law applies will be found in the contract. If you are on top of this enough to enter into those negotiations before the contract applies, then you want to look to see, you don't necessarily want your home state law to apply. You want to look to see, as a sales rep, are you better off under your state's laws or under the laws of the principal? Because you may find that you're better off by agreeing to the principal's suggested venue. or not venue, but statute. They're the law of that state. So it's an inquiry that you should make before you sign the contract. But I know typically that's not negotiated with the rep. So it's the language that's in the statute, that's in the contracts, I'm sorry, in the contract about whose state law applies is the first place to look. But as I mentioned to you, it is subject to being displaced by other considerations.
Okay. All right, and actually someone just asked probably the perfect question to close with today, and that is, do we contact Adam directly for additional information or representation?
Thank you very much for that question. That's why I have my information up here. Feel free to reach out to me directly. You have my email, you have my phone number. The nationalsalesrepattorneys.com is our website. We have a lot of information my firm does about our services for reps at that site, or just reach out, call me, email me directly, and I'm happy to speak to you and answer other questions for you. I have worked with a number of IHFRA reps over the years, and it's my great pleasure to be of service.
Very good. Well, in the interest of time, I just want to say thank you to Adam. Thank you for sharing just a wealth of information. Thanks for everyone who participated. Hope everyone found this as useful and helpful as I did, and that we can all benefit from this in some way, shape, or form. And I again appreciate everyone's time, and I hope you have a great rest of your day. Thanks again, Adam.
Thank you.